Good evening, everyone, or good afternoon. Welcome to the West Township West Orange Rent Leveling Board Workshop Meeting for March 3rd, 2022, 4:30 p.m. I just want to read a statement of compliance. Notice of this meeting was given to the Township Clerk and posted on the Township Bulletin Board and Township website calendar and sent to the West Orange Chronicle and Star Ledger. This meeting has been properly noticed to the public in accordance with the Open Public Meeting Act. No new matters will start after 5:30 p.m. For the members of the public, if anyone is attending, which I don't see anyone right now, if they do attend, this is a workshop whereby the members can discuss matters outside the hearing for the Rent Leveling Board, and we do not take public comments. If anybody would like to make a comment on today's meeting, they can simply call me at 973-325-4107 or email me at peacemeraldo@westorange.org, and I will be happy to reply to you as quickly as possible. With that, welcome everyone to the members of the board. Mr. Graziano, our attorney. So I want to just, I know at the request of the board members, we asked to have this particular meeting again to follow up with our last rent leveling board meeting, and we made it through. I think we had some good points come across. I think we had a couple challenges. This is my opinion, and I'm doing this as the outsider from the board because I don't sit on the board, but I'd like to offer my opinion if I can to you. And I think what we could do is build upon the successes and maybe possibly work upon some of the areas of challenge and try to build upon that. I think that's a fairly diplomatic way to say, we did okay. I will tell you that in my previous life in the fire department, whenever we had big events and things of that nature, we used to do a critique, and it was always good. And it was supposed to be a team building exercise. It was based on doing good, talking about good, bad, and good. And I think that may be appropriate for today, at least to start the dialogue. And I know this is the board's area to speak, and you are the board, and I am the administrator. But I just wanted to give you my casual observations and tell you what I thought about it, so that this way we can hopefully move forward. The fact that we started, it was our first event. We did start a few minutes late, so and that's partially my fault, and I need to make sure we start on time, and I think we should do that. I think we had the agenda in front of us. I think it was a little choppy because we never did a presentation like that before. So I think that's some of the things we have to do some critiquing on, how we move forward with it. But I think overall, I think with the guidance, Mr. Graziano, we were able to get through the meeting somewhat relatively unscathed. I think there were some areas where, like at the end with public comment, this is my opinion, when we allowed public comment, and this is where the chair needs to step in. And anybody who does sit in the chair, whether it be temporary or permanent, whatever the board decides, the chair needs to be more focused on the meeting and running the meeting and looking at things such as the public comment, where I felt that the people there that day were more testifying than actually providing commentary or questions. So I think that's something. And in the future, if we are going to have hearings, I think if they're going to be testifying, I think we want to make sure that they testify at the right particular time so that they have their opportunity within the hearing itself. And that's something I think where like the chair may have to try and rein that in. But that's my observations. And if I'm out of line for that, I apologize, but that's what I saw. And sitting on boards prior to this and other boards, that's what I've seen. And as a chair, those are the things that I've had to encounter and deal with as a chairperson of the board. So, and the fact is, it's for the lack of experience for some people here who haven't sat on the board or as a chair, those are growing pains, and I think those are things that we can build upon and make it better for everybody. So that was my observations. So that's how I'm going to start this off. Just so we know, as I mentioned before, prior to the start of the meeting with Megan, at 10 to 6, she will let us know, because we are slotted for no later than 6 p.m. So about 10 to 6, we will start wrapping things up. And if we need to determine to go further, we will. I did send out the agenda, the two items on the agenda are for to discuss today about the hearing, and then and Melinda Huerta did send in the ordinance to discuss a little further. And one thing I didn't do, I'm remiss in my duty, is doing roll call officially. So I apologize. So let me get into roll call and then we can start into the meeting itself. So yeah. All right. So we have Anthony Campagna's here.
Yep, present.
Asmer Michael's here.
Here.
Linda Wertz is here.
Here.
Kabir, are you here yet? I don't say, okay. Rodolfo Rodriguez is not here. He said he was going to be out of country. Deirdre, I see you're here. Welcome.
Here. Thank you.
And Councilwoman Williams, are you here?
Councilwoman Williams is having technical difficulties with the Zoom. She's going to restart her phone and see if she can get back in.
Okay. All right. With that, that is our reports to our subcommittee sections we're going to discuss today. I think I'm going to turn it over to Mr. Graziano first to let him comment, and then we'll turn it over to the board. Alex?
Peter, can I just follow up on the most recent comment you made regarding the members of the public who during the public comment section were actually offering what sounded like or what was intended to be testimony? I think maybe if at the conclusion of the applicant's case, then we should ask members of the public, are there any persons here who wish to offer testimony in objection to the petitioner's application? And then we can swear them in, as you said, and they can testify on the record, rather than just giving these comments that are really just that. They're not evidential, they're just comments.
So is that something that in our agenda, there's a line for that? And we just have to ask, them to raise their hand, so to speak? I know at like during town council meetings, you have to raise your hand in Zoom. Obviously, we're not in person. Is that the right process for them to be recognized?
I guess it's whatever, Mr. Campagna, it would be whatever process we determine would work best for us. I don't know that it necessarily needs to be an agenda item, testimony of objectors, because we don't know if there's going to be objectors until we actually have the hearing, right? Okay. So, but we just have to remember as a group, and Peter, perhaps you can gently remind us if we're in the heat of the moment and we forget. But when the petitioner, or we'll call him the plaintiff, is done with his case, we ask, are there any persons who wish to offer testimony in objection to this application?
Yeah, and Anthony, the piggyback on that, if we were talking prior to this meeting, we were talking a little bit about the planning board. And if you see how the chairman runs it there, what he'll do in some occasions, if it's in a specific areas of, they had a testimony last night of the planner and the engineer. They would ask the public for comments on that particular section. Then they moved on to the architect, and then they asked anybody from the public had any comment on that. So I think if we stick to that kind of format within the context of our hearings, if this is the petitioner, he's in and he has things to say, he's sworn in, does anybody have anything to say about this? It doesn't have to be part of our agenda. It's just part of the hearing. And if nobody wants to speak, well, then that I guess, correct me if I'm wrong, Alex, then that portion of the case is over. When we go to public comment, they cannot now testify against the petitioner because they had their opportunity.
Correct. I mean, it's one thing to comment on something, and it's another thing to give testimony within the hearing about it.
So I guess in our shoes, if someone were to only provide public comment, we would essentially have to disregard that when objectively reviewing an application. Is that the right way
I mean, we can't not hear them, but we have to just be professional about it and say, okay, well, that wasn't really testimony, that was just commentary. Yeah. Okay.
And just, I mean, I'm going to chime in here.
Ken, how are you? Ken,
I'm going to chime in quickly, and I don't know how long I'll be on this, but I just wanted to listen in a little bit. But the council, frankly, the township council, frankly, has made some errors in the past, in the recent past, with respect to the verbiage that's used in getting public comment on an ordinance. And I've suggested to the clerk that perhaps we should prepare a script, so to speak, to make sure that we ask the question the right way And you might do the same, something similar to that. So whoever the chairperson who's running the meeting is, they can use that script. I mean, you basically learn it pretty quickly and use it automatically anyway.
Yeah.
But
Okay.
when you have change in personnel, new people or old people doing new things, it's helpful to have a script like that. But it's true that when you're acting as an administrative body conducting a hearing, you are making a record. And that record, shouldn't be tainted or interrupted or affected by what I would call public comment, which has nothing really to do with that's not something you would be considering in connection with a hearing. And Alex, feel free to disagree if you do, but
No, I agree, Mr. Kaiser. And by the way, would everybody be okay with me using first names here?
Yeah.
yeah.
I feel like we all know each other now. But anyway, Ken, yes, I think it's very important to keep in mind, always keep in mind, we're making a record.
Right.
If somebody doesn't like what we do, there has to be a comprehensible record so that they can appeal it to the next body above us, whether it's a court or whether it's the mayor and council or whatever. But and on that, if I may use that as a segue to my biggest comment about this, and I say this with all love and respect to everyone, we are, during the hearing, we need to just be asking questions and listening to the answers and or clarifying things. There'll be plenty of time to make observations about things during the discussion portion after the hearing is concluded, after we've heard from the petitioner and any objectors. Then we can talk about how we feel about this. Should the guy have, for instance, done better due diligence than determined what the income of the property was? That was more commentary or that particular comment, and I forget who even brought that point up. But that's not part of the evidence. That's more for discussion once we've heard the evidence, when we're discussing it amongst ourselves on the record.
And to piggyback off that, Alex, one of the things I want to point out to everybody, when we are on a Zoom meeting, one of the things I will tell you is one of the things I observed was there was some commentary going back and forth on the everyone selection of the Zoom meeting. Well, the petitioner was on there also. So the petitioner has access to your commentary. So
that was in the chat.
That was in the chat, right?
Yeah.
In the chat area, in the chat. So I would just remind everybody, if you want to talk to somebody in the chat, make sure you do it specifically to that person, because there were some commentary going back and forth, and it was accessible to everyone. And if again, this is the learning part of it, but if this petitioner happened to see it and he wanted to appeal, and he would say, hey, well, you know what they were saying back and forth while I was sitting there. We just don't want to put ourselves in a position where we have to defend ourselves even greater. So I would just carefully remind everybody, if you are going to speak to one another that way, make sure that you do it in the private chat as opposed to the everyone or all.
Is there a way to make the petitioners not privy to that? Like, I know we all have the board link that we get. Is there a way that they can be?
That I spoke to Megan about that. Megan, if you can expand on that, please.
Sure. So the way Zoom works is that once they become a panelist, they have access to everything. Even if I move them out when they want to speak again, like the gentleman in the last hearing, he was a panelist. He presented his whole case, then he left and then was going to ask a question as an attendee. If I allow him to speak in Zoom again, he becomes a panelist. So you all get to see him. So it is a little tricky. You all can control that by chatting to, just
so you have the pick
Asmaret
list.
or just to one or the other.
Okay.
Well, but I'm gonna add that you really, in the course of a hearing, you shouldn't be chatting with each other. I mean, it's just like council members shouldn't be chatting with each other or communicating privately during the course of a public meeting. It's supposed to be public for a reason. It's
Mhm.
public. Everybody should be able to see what's going on at the same time. So I would, there really shouldn't be any interplay, communications between board members should be open, notorious, on the record. Nothing going on behind the scenes, whether it's through chat or otherwise.
And just so that you all know, the way the Zoom is set up, that when the copy gets transcribed, that none of that shows up, that's not available to anyone. It's only what's happening to you all within the meeting.
So it doesn't, it cannot be subject to Oprah because you can't get a record of it. But the point, like Ken said, is that the person's going to see that. So we should really just keep our comments to ourselves until after.
Yeah.
So. Okay.
My other comment, Peter, regarding the meeting, and I guess this is for us as a board to try to keep in line. The petitioner was jumping back and forth between being a fact witness and being an expert. And I did try to keep those two things separate. And for those who might not be familiar with what I'm talking about, a fact witness can testify to things that he or she knows or personally, or has seen or observed personally, facts that are within that person's knowledge. If somebody's going to give an opinion, like remember when the petitioner started going into, well, I did a study of all the rents for all the similarly situated units, and he started saying, and he was giving an opinion. Well, these are reasonable rents based on all the other similar units in town. That's an expert opinion. He has to be qualified separately. If he had an attorney, the attorney would take him through that. But I guess it's kind of up to us, because he didn't identify himself. He said, well, I'm a local realtor in town. Well, that's not good enough for court. You have to say, I'm a realtor. I've had my license for X number of years. I've done this kind of work in the past. I'm familiar with this market or that market. And then we have to decide, okay, we accept him as an expert, and now he can give opinion testimony. Otherwise, he should just be talking about facts.
So Alex, what's the process for that? Meaning he gives his first testimony and then he says, I would also like to submit expert testimony on behalf of myself. Here are my credentials and qualification. Would we then have to vote as a board to say, do we accept?
Correct.
His
Is this
submission?
guy, is this witness who's attempting to qualify as who's attempting to give expert testimony, do we recognize him as an expert in whatever field he's giving testimony? And that, I mean, we don't have, just because he's has X number of years of experience, or he knows this or knows that, or we don't have to accept him as an expert. But I mean, unless there's a really good reason why not, I mean, we can hear his testimony as an expert, and we can decide, because remember, even within that, Anthony, we can decide what weight to give his testimony. Like, yeah, he might have been a realtor for 32 years, but hypothetically, well, I think his opinion's crazy. I don't agree with it,
Okay.
Wouldn't it be
And
considered a conflict of interest in his case?
so, yeah, that was going to be my next, but is it okay to serve as both a fact and an expert witness for yourself?
Yeah, I mean, usually the Asmer, those are different people. Usually in the usual court scenario, fact witnesses and expert witnesses are usually different people. But here, I mean, the guy is his own. He's testifying on his own behalf and doesn't have an attorney. It's kind of real low level stuff. So.
And the truth is, he when he's doing that, he's not an expert. And Alex, I think you'd agree with me that while we often, in fact, I think we always try to follow the rules of evidence in these kinds of matters as lawyers, because we're used to them and we use them in court all the time. But the truth of the matter is they don't really apply strictly in an administrative hearing.
Right.
Although I do think, I have tried administrative hearings before the Office of Administrative Law, and then I always follow the rules and try and qualify an expert if I have one. But it's really, the rules of evidence really don't apply other than privilege. And so, but it's anybody who comes in and, I didn't see this hearing, obviously, but if I were an applicant appearing pro se, or if I was representing an applicant and I needed expert testimony, I'd call an expert and qualify them anyway. Whether
Right.
just because it would give that witness more weight and make him or she more credible and more persuasive. But if anybody who thinks they can testify in their own matter as their own expert is not thinking very clearly or effectively.
But I think, I think, Ken, that goes to what weight we should give his so-called expert testimony.
Right.
But
I mean, it doesn't mean he can't try to
Right.
give it, you know, but we can decide what we want to do with it.
Exactly. I agree with that.
So Mr. Graziano, I'm sorry. So does that happen before? Is that something that we discuss afterwards? You know, I think that's where it gets a little bit blurry for me. You know, do we ask the person that's testifying, you know, while he's switching back and forth between expert and fact witness? So do we ask those questions, or do we make him clarify that beforehand?
I think, Melinda, the best way to handle that would be now that particularly with this applicant, now that we know, we'll ask him again. Now, do you intend, you're going to testify as a fact witness, Mr. I forget the guy's name. But are you also asking to be permitted to give expert testimony before this court? In other words, opinions and things like that? Because if so, we have a couple of questions for you.
I have a
So,
question. I'm sorry, go
that
ahead, Linda.
It's okay. So would that be on the agenda? Is this part of the script that Mr. Kaiser recommended before?
I think it's part of the script that, you know, that if somebody, you know, we could do our script as kind of a flow chart. If somebody attempts to, you know, testify as an expert, we need to ask them the following, you know, 1, 2, 3, 4, 5. And Ken, for your information as well, we did agree, just as a framework, you know, to follow the rules of evidence, but to relax them wherever, you know, the interests of justice required, you know. So we didn't have the rule book out. We were just kind of, you know, proceeding generally under the rules of court and the rules of evidence.
Right. I understand. And I do pretty much the same thing if I present to the council an ABC hearing for violations or whatever. That, I mean, it's something we all kind of tend to do as lawyers, I think. And I get that, and I don't have any disagreement with it. So. And I'm going to stop talking about, I mean, I wasn't there for the hearing. I really don't have anything to say with respect to the hearing. I didn't realize, I thought this was going to be largely about the ordinance, and to the extent that I become involved with, you know, preparing or drafting changes to the one we have now, that's really the part I wanted to be a part of. And I'm just going to listen from this point forward until we get to that point, at least.
One of the things I'd like to point out, because we were talking about the process of the hearing itself and how we went through it, and I'd like to talk to Deirdre, because I think we want to talk to her, because how did you feel in that role? Did you feel like that you were missing stuff, or were you uncomfortable with it? Did you feel like you needed some assistance from us? You know, and I don't, and just so you know, I'm not supposed to speak at that hearing because I'm the administrator. And Mr. Graziano and Alex can give you advice, but you know, if you weren't feeling comfortable, why don't you tell us your experience of it and how you feel about it, and now that you have one under your belt, what you think about it. So you got to unmute yourself, though. We can't hear you.
And if you'd like to be the permanent chair.
I'd like to say that I was initially uncomfortable, but as we proceeded, I began to get more comfortable with the hearing and running. I certainly appreciated the support and the guidance that I was offered throughout the process. And as I received the guidance, I began to feel more comfortable. And I'm going to make it my business to watch. You know, they have these hearings on YouTube. You can watch hearings where they're utilizing Robert's Rules of Order And I'll just watch a few and take notes, and I'm sure I'll just get more comfortable with the process.
Okay.
So that's my 2 cents. I think I could become comfortable, even though initially, of course, I wasn't. No way.
That's the whole point of today, is to discuss those things and see how we are with this, where we're at, our positions with this.
I think you did an admirable job, Deirdre, just being sort of thrown right into the fray, so.
Thank you.
Now, correct me if I'm wrong, we did vote on this last time for the meeting. Was it for one meeting? I honestly, I don't have it in front of my record. Is it for the next meeting also, or are we continuing with that? And that's a decision for the board. You guys have to decide that yourselves, and whether, Deirdre's actually comfortable with still continuing with that process, or somebody else would like to step up and do that. That's a decision for the board, but I believe we just did it for that one particular meeting. So
That's my recollection as well, Peter. It was, we just voted for one meeting, so we'd have to make a decision going into the next
Yeah,
one.
so the board has to make a decision tonight what you want to do going into the next meeting. So that's why I wanted to bring that up.
Would we do that today?
Yes.
Do we have a
Okay.
quorum with the 4 of us on?
So does someone have a motion?
Well, we have a quorum because to do a vote like that, we do have a quorum. We have there's 7 spots on the board. I mean, that's for the board to discuss too, but we do have a quorum to make that kind of motion and vote if you guys choose to do so. That's up to you. As again, that's up to the members of the board. And I think that's a discussion you guys should have. We stay out of it. So.
Yeah, is it something where, I know when we were originally kind of setting up those little subcommittees, we could do a chair and a co-chair, just so that there'd be, I don't know if it's a more formalized support for Deidre in that capacity?
That sounds good to me.
Yeah, I just want to make sure you don't feel like you're left out, left out to dry, that we're all kind of learning as we go.
That works for me.
Just
Can we
for-
make a motion to have a chair and a co-chair?
Co-chair?
Is that what we're discussing, or are we discussing a chair for the next meeting or for the next hearing?
I guess since Anthony brought it up, what would be the purpose of the co-chair? Does the co-chair actually participate in meetings, or does the co-chair only fill in if the chair is not available for some reason?
Yeah, I guess in my mind, able to step in and help along the way. So in an active capacity during the meeting, if Deidre needs help or guidance, or there seems to be a blockage, the co-chair could also step in to further things along, to help follow Robert's Rules of Order, to facilitate swearing in or stopping public comment, just keeping the guardrails on in a sense.
Well, I think what Robert's rules would suggest is that you should always have a chair, only one chair.
Okay.
Okay.
But you also should and could and should have a vice chair, if you want to call it that, or
yeah.
Because if there's a time when, for example, Deidre is not available or not able for whatever reason to handle that position, then the vice chair would take that role on. But I don't think you can have more than one chairperson at a time.
Got
And
it.
I think as a practical matter, you're all kind of trying to help each other, I hope.
Yeah.
So in terms
You
of.
don't have to be a co-chair to jump in and help Deirdre.
Right.
Okay.
Amen. Amen. to that.
The only other thing I'm going to add is, there's a reason why the council and why most boards, I think, and commissions who follow Robert's rules have one person do the job for a term, whether that's a year or 6 months or whatever the term is because then they get accustomed to it. And as Deidre pointed out, she wasn't real comfortable in the beginning. She's more comfortable now. She's going to get increasingly comfortable as she does this going forward, if she does. So my view is you handle it like almost every other organization does, and have one person in charge at a time and for a term, whether that's a year or half a year, whatever it is. And then, at the end of that term, consider whether you want to have somebody else do that job the next term. And just so you know, the council, the township council, by its rules, prevents a council president to serve more than one term. I mean, they can serve it. There has to be a break. You can't do 2 terms at once. And there's a value to that too, I think, because everybody gets a chance to serve in the role. And I think that's a good thing.
Yeah, that sounds great. So if we set a term for the initial chairperson and then create the vice chairperson role, or I guess it sounds like we can all act in that capacity just as board members to step in when needed to help facilitate the meeting, to remember things we have talked about, to support the chair position. That sounds great to me.
But there should be, it wouldn't be a bad idea to have a vice chairperson.
Yeah,
you
just
know,
in case someone's unavailable.
Because if Deidre can't be there, or whoever's the chairman can't be there, then that person has that responsibility.
And the board is they sanctioned it through a vote saying that this is the person we elected.
Mhm.
You know, and as a suggestion to you, if you're going to do that, most boards change over in January, and because that's when the appointments change and everything else. So if you are going to make a motion to have somebody be the chair for the remainder of this year, if that's what you choose to do, then you would say that the term is from now until December 31st, and then in our January meeting, you can have reorganization, and you can appoint a new person if that's what the board chooses.
Yeah.
To do.
Yeah, I'm supportive of that.
Well, my question
Melinda,
is, Deidre,
Yeah,
would you like to be the chair? I mean, it's not an official motion. It's just more of an opinion. Like, what do you,
sure,
how do you feel?
sure. Fine. That's fine.
So I motion to make Deidre Poe-Sanders chair.
then
Before
we'll-
the motion, I do have a question. Deidre, do you
Well,
feel
wait a minute,
comfortable?
for technical purposes, we have a motion, so we have to have a second, then we can have
Oh,
discussion.
Okay,
So then you can have a discussion about it. So you
Okay,
can-
okay.
Okay, so you can discuss. We have a motion by Melinda. We need somebody to second it.
second.
Okay, now we have it open to discussion. There we
Okay.
go.
Deidre, do you feel comfortable, for an example, in the meeting, in the last meeting, I felt like there was a board member who was being too accusatory towards the landlord. And I feel like as board members, our role is to be fair and conduct a fair hearing. And we can be firm, but we need to be fair. And I felt like the tone of this person was very accusatory, and it's not fair to the landlord who, is coming to us and expecting us to listen to him or her with open ears. And I don't feel like that's how the meeting went. And correct me if I'm wrong, you guys. Do you feel comfortable almost saying to any of us, right, or that person or anyone, maybe we need to tone it down, or because again, it looks bad for all of us as a whole, as a board, even for the town, because then tenants and landlords won't feel comfortable coming to us if we do sound accusatory without even hearing everything it is that the person has to say. We just remember to be very fair.
No, you know what? I think I could get comfortable with that because we're all getting to know each other better as a board. So it really is nothing personal, right? We have to hear all sides of the story.
Exactly.
And as long as I have the authority as a chairperson to kind of pull that situation in, if that's allowed, I'm comfortable doing it. I will do it.
You certainly, I'm sorry, Deirdre, but you certainly do have the authority, because you're chairing the meeting in such an instance where as Esmeralda is bringing up, you could say, okay, board member so-and-so, let's save that point for when we have our discussion, and let's stick to asking questions and listening to the answers for now.
Okay. Yeah, I feel comfortable doing that.
Yeah, I agree. I think it's a great point, just to ensure that kind of the unbiased fairness of hearing all parties before offering our views or opinions. Agreed with that completely.
Yep. I'm comfortable with that.
Is there any other discussion among for this in this particular motion in regards to what we were just or was
But
mentioned?
one
Do we-
other point.
Do we just need to put oh, sorry, Alex. go
Yeah,
ahead.
I think you and I were going to say the same thing, Anthony. Melinda just said she motioned for Deirdre to be chair, but we were talking about 4 terms.
Yeah, term, yeah.
So
So I think, yeah,
And the
Melinda, I
motion-
think to expand on your motion, do you want to make a motion to elect
Yes,
Ginger
I'll make-
as- for a period of time?
Yes,
That could be part of the discussion also. So, you want to amend your motion. Let's put it that way. You want to amend your
Yes.
motion for a period of time?
yes.
And what period of time would that be?
1 term ending in, or beginning in January, the next term beginning in January, right? Is that,
So the term would be from January 1 to 12/31 each year, each consecutive year for
Yes.
this,
Yeah.
for this particular motion. Is that
yes.
okay? Right. So that's open discussion also because we amended the motion. So, so anybody would like to discuss that prior to the vote?
That works for me. Just I guess a clarification question, because our seats are appointed by council members, the council members would take their seats 1-1. Is that the term for council members
Correct.
when elected? So they'll be able to, place their appointed positions prior, essentially, hopefully before
I believe your
the
appointments are for
January
2
term.
Your appointments are for 2 years to this particular body.
Yeah,
But it's.
but when they would fall,
Right. And the
I'm just thinking-
council,
yeah, we would want them to coincide in a way. So, right, the 1-1 swear in for our new council members, they would in effect be able to appoint their new position. That person would then take their role in our January, in this body's January meeting. So it would be
Correct.
coterminous, which is great. Yeah, okay, works for me.
which we would probably want to have it as a workshop meeting to do that. So
Yeah.
if we had a meeting. So we can get that
one
done.
more point of clarification, ladies and gentlemen, because we've got the vote to appoint Deirdre as chair, but then we have but I think it's a separate we can appoint Deirdre as chair for the remainder of the year, but it's a separate vote that we have 1-year terms for each successive chair, because we're kind of mixing. the
Yeah,
two
we're
ideas
conflating the
into
two.
one motion
Yep.
otherwise.
That's great.
I think I remember the old go-to aphorism was one notion, one motion. I remember reading that in a book about Robert's Rules of Orders one time. So we got.
That
we
is too
have-
funny. I was on a National Association of Parliamentarians meeting, and one of the speakers said that, and I was like, people still say that? You just did as well.
It's a good way to remember.
Yeah, wait, you're all gonna remember it now.
There you go.
So I guess what we're saying here is that is this the motion that we made, Melinda, that you're looking to make a motion for a 1-year term for the board members with Deirdre in that position this year to fill that position until 12/31. Is that correct?
Yes,
Right, and we had the second on that, correct?
Correct.
Anthony?
I second it.
I'm sorry, Asma, I'm sorry. Asma. Okay, so if we're all done with discussions, I'm going to put the motion forward. Those in favor, I'll do a roll call. Mr. Kamanya, Anthony,
Aye, favor.
Asma,
Aye.
Deirdre,
I,
Melinda.
aye.
Okay, and we have, okay, is Kabira in now? No? Okay, and, all right, so motion carries 4-0. Thank you.
And did we have the second motion now to make any particular chairperson is going to serve for a 1-year term beginning on January 1 and ending on December 31 of any given year? That's a separate motion.
Perfect. So I'll make
Graziano,
a,
just one more question before the motion is made. Is that something that needs to be stated in the ordinance?
No, I'm relying on the provision in the ordinance, Melinda, that where we're saying that we can make up our own rules, to effectuate the purposes of this ordinance.
Understood, thank you.
Okay, so the second motion,
yeah, so
which-
I'll make a motion to state that the chairman position holds a term of 1 year, and it cannot be held in concurrent years by the same board member thereafter.
I second.
That's pretty.
I have a question. Why would we not, if you had an effective chair, make the body do a rotation?
I believe that's what they're trying to do, Councilwoman. They're trying to, it would be no more than one year in the position, and it would rotate based similar to what the town council does.
Well, no, I
So
think,
let's
I'm sorry.
not, yeah, we don't do that on town council. We don't have, I mean, you serve for 1 year on town council and we elect a new person and the term is for 1 year, but I'm asking a little different of a question because this is a different type of board. What if you don't have a strong person that wants to lead and you have someone that is willing to serve? Do we want to automatically say you can't serve as the chairman for 1 year if you have someone that's willing and able?
right, and
Because the body
Councilwoman,
still votes. Go ahead.
Councilwoman Williams, I suspect that the notice for the notion for the motion, so to speak, resulted from my comment made earlier, which you may not have heard. I referred to the council rules, which provide that a council president can't repeat during the next year, but that wouldn't be true necessarily of other boards or commissions. And I don't see any reason why you don't need to make that rule if you don't want it. You can make it if you want it, but you don't have to have it. So you could just leave that out of this motion and leave it up to the, the board can always make a change down the road if it wants to. It can also keep the same person in place, and it really is a matter of choice.
I'm thinking of the
that's totally
zoning
fine.
board and the planning board. The planning board has had, they do have the option to rotate, but we do have a strong planning board chair, and he hasn't served in the past year after year, and the same with the zoning board chairman as well. So again, when you have a strong person, they're willing and able, I wouldn't want us
no argument
to
on my
just
side.
negate
Right.
that.
And the reasons and the policy reasons behind the council rules would not apply to a board like yours. So you're not politically involved. You're not elected officials. You're appointed. So it's a much different situation.
Okay, so I'll amend the motion to remove the concurrent term limitation.
Restate your motion.
Yeah, so
I'm sorry. Restate it for me. So,
make a motion to state that the term for an elected chair simply runs 1 year, and from January 1 to 12/31.
okay. And we have a second. Asma, you second?
Yes.
Okay. Any discussion? Seeing none. Take a motion. I'm going to take a vote. Anthony Campagna?
Aye.
Asma Gebram, Michael?
Aye.
Melinda Huerta?
Aye.
Deirdre Post Sanders? Motion carries. Okay. Now, the other motion, I believe you were discussing before, if you wanted to continue with it, did you want to make a vice chair? And if that's the case, then that's for you guys to decide.
Yeah, I'd be supportive of that.
So,
My apologies, I missed the comment.
Just talking about if we do want to formalize the vice chair position, so we'd motion to create the vice chair.
Okay, so you're gonna make that motion, Anthony?
Yeah, so I'll make a motion that the board creates a vice chair that would serve in place if the chair is unavailable for meetings.
Okay.
And
I
I second that motion.
Seconded by Deirdre. Okay. Okay, take a vote. Anthony?
Aye.
Asmert?
Aye.
Deirdre?
aye.
Melinda?
No, aye.
All right, so motion to make vice chair. Now, with that, do we want to make a motion to have that term run concurrent with the chairman? So this way, we would do this every year also.
Yeah, agreed.
Is that your motion?
My motion would be make a motion to have the vice chair position run with an annual term, Jan 1 to 12/31.
Okay. Okay, we have a
I
second.
second that.
Okay, Deirdre,
Yep.
Okay. Any discussion? Okay, no discussion. Anthony,
Aye.
Asmith,
Aye.
Deirdre,
I,
Melinda?
Aye.
Okay. All right, so we got that covered.
So who's, Anthony, you're gonna be our vice chair?
Now you have to make a motion to do a vice chair. So,
oh,
Asmith, are
boy.
you making a motion?
More than happy to serve in that capacity if the board will have me.
All right, well, I motion Anthony Campagna as vice chair of the Rent Leveling Board for this year, ending December,
31.
yep, 31st.
Second.
I second
Am I,
that.
yeah, am I allowed to
No, you
second
can't
that?
second. No, you
I
can't
can't
second.
second.
Because
I
discussion,
second
you might
that.
talk yourself out of it. Deirdre, you second?
Yes, sir.
Okay. All right. Discussion? Seeing none. Anthony?
Aye.
Asmund?
Aye.
Deirdre?
I,
Linda?
Aye.
Okay, congratulations.
All right.
Put up your left hand, you're all sworn in.
Now, what about a secretary? Don't we need a secretary too?
Listen, you're the new kid on the block. Let's not get across that line.
Okay.
I don't need that job. That actually is, it's in the, that is actually in the ordinance secretary position, but we do not have a secretary. And that is something that we've been discussing actually operationally here, because as the administrative officer, I am not the secretary. However, I have been filling in the secretarial duties. And that is something that we will be discussing with the administration here to see what we can do to handle that. So I think we did discuss at one of the meetings that the secretary wasn't going to be an appointed position. And that, correct me if I'm wrong, if you guys remember that it was going to be more of somebody who was a staff position here.
Yeah, we had talked about seeing if we could allocate some time from a current staff member in the administration to serve in that capacity.
Right. So, and I will report back to you to let you know what we're going to do with that. So if we can work that out somehow. Right, because it's somebody who was actually in the government, they can work it out and do all the work here while they're at the office. So, okay. What's next? Oh, I'm sorry, Madam Chairman, Madam Chair, Madam Chair. This is your meeting, so you start running it.
now listen.
You've been elected. You're duly elected. It's yours now.
See, I'm totally confused because I thought this was just a, I don't know how you call it, but I thought this was just a, like an informational meeting. So basically, whatever type of meeting we have, I am the chairperson. So
Correct.
I run all the meetings then.
Correct. Technically, yes.
Okay.
I'm here to help you out, but I like to delegate.
Okay, boss. All right, let's see where we are.
Deidre, if you need some support with parliamentary procedure, I normally do a workshop for the teens for Jack and Jill. And I have a handout on just basic parliamentary procedure, Robert's Rules of Order, just things that are just to run a basic meeting. So I will share those with you. I'm happy to share that with everyone. I kind of teach this class sometimes a lot, but more than happy to share the information with everyone so that you'll have a basic understanding, if you don't have one, of how to move a motion, the proper verbiage to use, and I'll get that out. If not tonight, I'll get it out tomorrow. My daughter has a performance tonight, so I apologize. But I will share that information if I found it to be exceptionally helpful in just understanding what's the right terminology to use.
Okay, that sounds like a plan. Okay. So now, now the agenda went away and I appreciated having it up on the screen. There, it's back now. So it looks like there's only one other item on the agenda, and it looks like it's just the ordinance discussion. Correct me if I'm wrong.
Correct. Melinda sent to me yesterday a modified version of some commentaries on the ordinance, and I did send it out to everybody, so that you could review before the meeting. I will tell you that I have had some issues with some people. Some of the people, the board members, have had issues with me delivering the documents to them because of either mail server size or things of that nature. Part of it, I can only produce about 25, I think, megabytes out there. I think that's what the number is, something that can go out. But some servers can't accept that many. So if you want in the future, if you need me to print things out, I will do it. There's no sense me printing a lot of items and nobody's going to take it. But I can on a case-by-case basis, if you want me to print it out for you ahead of time, and you can pick it up here at the town hall, I could do that for you. So, but just please let me know. But I try to send things out electronically because sometimes it's a lot easier for people. They just use a computer and they just look at it as we go.
Peter, I think we also discussed about doing a Google Docs, using Google Docs for our, document.
We just discussed about getting a secretary, didn't we?
Oh my,
So
okay.
if you would like to volunteer to do the Google Docs, Melinda, congratulations. But you got to remember one thing, with Google, we don't use Google here in the township because of the security of our systems and things of that nature. So for us to use Google Docs, it's a little difficult, a little challenging. And be honest with you, I'm not the IT person to tell you that I can get that accomplished or not, because
it doesn't work well.
Yeah, I checked with our IT person, and I did ask, because I know, Melinda, you were one of the people who had a problem with it. We discussed Gmail and stuff, and he basically told me that it's not going to be easy for us to do it from our end. So if you would like to submit Google Docs, that's fine, and we can open them up, but I really can't produce them from our end.
We can't open them we can't open Google Docs if she sends it to your westorange.org email, you can't open it.
Right. You would have to actually create
You have
to actually open up a West Orange Gmail account, which can be done, but there's permissions and there's a lot involved with it, because we're worried about the security of our computers, and that's why we don't send things out that way.
So let me ask, does anybody have any comments on the ordinance? Did anybody have a chance to review it?
So I reviewed the comments that came through. I just had a point of clarification on the definitions that we want to add. Is that something where, like, is there a common source we can use, right? Defining tenant, defining rent, defining landlord. It just feels like something that should be in the the common lexicon of legal proceedings. Is there something we can draw on from all that stuff?
If I can chime in a little bit here, because this is really the reason that I figured I would participate in this.
Yeah,
because at the very end, there's probably a likelihood that I'm going to be the one who's not drafting per se, but putting together an ordinance to give to the township if the board decides that the changes are needed, and if the council decides that it wants to make changes. And I guess at the outset, I'm wondering, without knowing, whether there might be a model rent control, rent leveling ordinance, whether prepared by or known by the League of Municipalities or otherwise, dealing obviously with the state of New Jersey. And rent control is not unique to New Jersey, I don't believe. So there may be a model ordinance out there that's prepared by some real estate law group or whatever. But that might be a good place to look. You need to remember that any ordinance, all the parts need to fit together so that it creates a workable whole. And that's kind of a problem. And the way we've always tended to do ordinances, we start with somebody else's, which is, I think, often a mistake, but it's just what we all do, in part because it's probably easier and we're lazy. But we start somewhere and add here, subtract there, and so forth over a period of years. And you need to remember, if we could come up with a comprehensive ordinance, that might be a great thing. But I think you'd want it to start with somebody who's thought this through and figured out how all the moving parts work. That's why I'm wondering if there's a model out there that might be available. The other thing
I
is
might-
that, go ahead.
Sorry, I did include at the top, nobody has commented besides Kabir and myself, and yourself and Tammy also made some recommendations, but at the top I did include the ordinance, Verona's ordinance.
Verona,
Yeah, so I thought that that would be, you know, one of the ordinances, since we took Verona's ordinance in the beginning, our original ordinance is a Verona ordinance, basically.
I think actually our ordinance predates, our ordinance goes back to 1977, I believe, maybe even 72, right? So, and obviously it's been modified from time to time since then, although not very much. And I don't know if Verona had an ordinance before that or not, but I don't think so. I could be wrong, but again, we're not married to anything in particular. And remember that ordinances can change over time. You can add to them, subtract, you know, from them and so forth. So it's not like you're locked in place after you make changes or after you create the original ordinance or after you make any change. It does require a process that you go through that takes several weeks, if not a few months, so that you can actually affect the changes. But so that's why I'm here. I looked at the comments that were there other than my own, and frankly, they raise a lot of questions. And I'm not sure, you know, what the best way to proceed is. And I'm happy to have Alex handle this aspect for the most part, because I have more than enough to do. And I just know that at the end, I'm going to wind up having some responsibility for any changes that are made. So I figured I would listen in and see how it goes.
Well, would anyone like to make their comments public? I mean, like, is there anything that jumped out?
I mean, one other point that I thought was important, I think just for us to discuss on our view, was the idea of what constitutes a major new improvement. In the comments that were in here, it said something like a roof, like replacing a roof doesn't constitute a major new improvement. It has to be related to improves the quality of life of the tenants of the dwelling. So I don't know if that's to me that felt a little bit opinion based. So I don't know how we want to treat those types of items as a board.
I agree with Anthony.
So I guess, Ken, is that something where we should see what else is out there and kind of pull together what we'd say is best practice or common practice for rent leveling boards?
Yeah, I mean, I don't know if there's a best practice, frankly. And here again, I'll defer to some extent to Alex, because he's actually, you know, handled the Verona rent leveling board for a long time. So he's probably going to know more than I do about these things. But I mean, just going through the comments, for example, I saw Kabira's comment, put exemptions in a separate section. And my initial question is, okay, why? And where do we put it? You know, she gave the conclusory language without really explaining it. And so forth. I mean, there's just a lot of things here that I have questions as to why you want to make these changes and where you would put them and so forth. And I don't want to take over. I don't want to influence the board in that respect. I just want the board to know that at the end, I'm probably going to be responsible for tying whatever changes are made together and putting them into an ordinance that's going to go before the council for approval.
Mm-hmm.
So I'll just speak a bit because that was my comment about the major capital improvement. I added that because that is something that I saw was common in other ordinances. So for example, the Verona ordinance, and at the top, I also have a Newark ordinance. Orange has a rent ordinance. So those are some common definitions that I found in those ordinances. And it does indicate, so I'll just read Verona's ordinance out loud. A major capital improvement, a permanent improvement that is reasonably expected to last more than 3 years. The improvement must benefit the dwelling and must be subject to an allowance for depreciation under federal income tax provisions, but the rent Control Board, taking all factors into consideration, will make the ultimate determination. Capital improvements shall include but not be limited to new construction related to the dwelling, new bath fixtures, kitchen cabinets, kitchen fixtures, air conditioning installation, heating system installation, electrical rewiring, electrical outlets, and replacement of doors, windows, or other fixtures. Incidental repairs, which are defined as expenditures that keep property in an orderly, efficient operating condition and do not add to its value or appreciably prolong its useful life, shall not be deemed capital improvements under this article. So that's where that, so
I
that's,
find-
Mhm,
Go
I'm
ahead,
sorry.
go ahead. I'm sorry, babe, go ahead.
It's okay. That's why the definition that I put, I believe, I don't remember exactly which ordinance, but it was one
Yeah.
ordinance that, it came from some ordinance.
Yeah, good. I mean, I think that's great because it's a resource that, right, an applicant can look at and say, all right, does what I'm doing to this building qualify under these, criteria? So that's great. I just wanted to make sure we were kind of within scope defining those things.
Right.
And I think, right, we have the ability to say, do we want to define those things, or do we want to have an objective view, or do we then retain the opportunity to have an objective view to hear the case of, right, if a house needs a new roof, does that count? If it's a remodel of a kitchen, does that count? Right, there's obviously a lot of room for interpretation on what those capital improvements mean and how they're defined. So that's great. I'm appreciate that that clarification. Thanks, Melinda.
No problem.
Because one other thing that you need to think about and consider when you're looking at other ordinances, for example, Newark or Verona, both of those jurisdictions are much different than West Orange. And so you have to ask yourselves the question, does this fit for us? And one would kind of hope that in New Jersey, everybody would be pretty consistent, but the truth is they're not. We have 560 some municipalities in the state, and they all have different rules and so forth. They all are structured by the same state statutes or similar state statutes, but they all have uniqueness about them. Verona's a small town. I don't know how many square miles, Alex, but it's we have 12 to 13 square miles. Newark is a much different socioeconomic background than we do, and it's huge compared to us. So it's really, there may be things that apply in all these towns, but there may also be reasons why one town's ordinance would differ from another. So this is hard stuff. No question about it.
Do you think we need to give more time or spend more time reviewing these ordinances and comparing and contrasting because I feel like I didn't have my hands on the email for such a long period of time. I don't recall, but I feel like it was fairly recent, if I'm not mistaken. So,
we've had, I've been waiting for some input from, any of the other board members, because we have had the ordinance this whole time.
Okay.
The original comments were sent out last June by Ken.
Yeah.
So they have been out there, and I've sent them out multiple times. So if you take a look at it,
And
they've been out there. So I mean,
and we've been asking for input from, the other board members, and I just haven't gotten them. So I don't know if you've been able to explore other ordinances. So we definitely need to get something put together to present to council.
So just to clarify,
a couple things. First of all, you can use the ordinance that we have. Obviously, right now you have to use the ordinance we have in place, and it's been in place for a long period of time. And one way to look at this is, as you're having hearings and so forth, you're going to see where problems arise, where you have questions. Well, what does this word or what does this phrase mean? Is it not clear enough? And if it's not, hey, maybe we need to change our ordinance. And so that's one of the things that I think you're naturally going to, consider as you work through hearings. One of the, Melinda had a comment, add to definition, fair rate of return shall mean a return of 5% on the landlord's investment and so forth. And I guess that may be a good, I don't know what a fair rate of return is. And I think in order for me to know, I'd have to be an expert in economics, landlord tenancy, and so forth. I don't know how you arrive at that fair return. So it's not bad to have a number like 5%, but where does that 5% come from? How do we know that's fair? How do we know that's the right number?
5% in real estate is not a good return. I can tell you that right now.
Right. So
from a professional perspective, no investor is going to take an investment if their return is only 5%. You don't have any room for error. You don't have a vacancy rate. You're not taking into so you're not going to make money.
So
again, some of this stuff is going to have to be left to interpretation and may not even come into consideration when we're having a hearing.
So then should we table this for now and maybe meet one day? I mean, Melinda, do you feel comfortable meeting in person to go over this and talk?
Yeah, absolutely. I mean,
Board
think
members, do all of you feel comfortable meeting in person?
You can't, just to clarify, as just so you know, you can't violate the open public meeting. The board cannot convene individually as a body without being noticed to the public.
Okay.
So 3 people or less can meet without violating the Open Public Meeting Act, and you can have your own working group, which we did create subcommittees. I don't know. I believe there is room on Linda. There is room, one more spot for a subcommittee, right? On your subcommittee, you and Kabira, I believe. Or somebody else on
I believe it is. Rodolfo is supposed to be on there with me, but he has not. We have not met.
Okay, so if maybe Asmund, I can reach out to Rodolfo and see if he would like to concede that spot, if you would like to be on there, and then this way you the 3 of you can then sit down and discuss those items without violating the Open Public Meeting Act.
Peter, I'm sorry, you're correct. There is a vacancy. So
there is a vacancy, right?
It's just Kabir and myself on here.
And I'm not even throwing myself out there. Deidre, Anthony, if any of you guys want to as well, we can all discuss. I just figured maybe we all come together to talk about this. And
I mean, I do think that we all should have input in what's gonna change or where we see, adjustments need to be made. So.
Can I offer an observation, ladies and gentlemen, having just, participated in the overhaul of the Verona ordinance, which was passed last year. We were asked for our input as a board, and I was the primary point of contact between the municipal attorney and the mayor and council. But I mean, we have to have some experience with working with this ordinance before we can decide what works and what doesn't in it. I mean, we're a newly convened board. We've had half of a hearing so far. Is that really enough to pick out section 15.2 and says, oh, this has to go, this doesn't work? I don't know that we have enough experience as a group yet to be able to comment on overhauling this ordinance.
Yeah, that was one of the things that we had talked about.
Yes,
might have been like 6 months ago. And Ken, I appreciate your comments just now because it kind of reiterated what you said before, that we don't know what we don't know, and until we have a hearing that puts us, in a spot where we don't either have direction or are unsure about a topic or item or clarification, we don't know what we don't need or don't know what we do need. So I'm of that opinion as well, not to kind of go in and carve this thing up without knowing how it's being used effectively right now, given it hasn't been, right, the rent leveling board hadn't met or had a hearing in, 2 decades. So, we'll take it as we can and we'll operate under the existing ordinance. And if and when we find deficiencies or areas that need clarification, we can act on them then in due course.
Right, and we
Okay.
kind of go back to the same. Well, it hasn't been enforced, right? And it hasn't been enforced because people haven't been aware that it exists, and so we kind of come round full circle. Can we start to advertise this and start to reinforce this ordinance with our landlords and our tenants? Because as it exists now, it's not being enforced.
What's not being enforced? So I would just step back away And I would remind us that as the administrator, Mr. Smeraldo has been diligently working to bring our, residents up to speed if they indeed qualify and should be registered. So when we say as a board, we haven't been enforcing, we didn't have an enforcement mechanism, and we just got back to this. So that was one of the things as well, that there may be some things that as we have hearings that we may want to just address, and there's no issue. The council can look at an ordinance and take a couple of pieces out, or in total. I just don't think we should throw the baby out with the bathwater until we understand what this is going to look like in West Orange. We may be doing a complete revamp for not. There's no guarantee that with the ordinance as it stands, we're going to get a tremendous amount of cases or hearings or requests for hearings. So is it that you're asking that we take the rent leveling board and make sure residents know that they have a vehicle if they have complaints? And that's just like we had talked about before, which was a PR push just to make sure people know we exist.
Right. So when we talked about the PR push, we were hesitant about the PR push because we were considering either revamping or making adjustments. And before we can do a PR push, we have to make sure that our ordinance is going to be enforced, or it's going to be the one that we're going to have our hearings based on.
But so for us, the way it has to work is we have an ordinance, and we have to do our current hearing based on the way the ordinance reads until we change it. And it seems like we're having a consensus that people don't really know what to change or how to change it yet until we really start functioning, which is where we're kind of there now. So, we've made some changes that were hot topics. We have a chair, we have a vice chair. We're going to have the administration review whether or not we can get some secretarial advances made. And then once we start having hearings, we come back and we say, this part of the ordinance, we need to immediately readdress this. And then it can go to our legal department, and then it can be presented to the council. But again, we don't know what's going to work. So I think while we have all of the recommendations and changes and suggestions from other municipalities, I still think we've got to figure out what is going to happen in West Orange.
So for example, like on our ordinance, we have the filing fees and all of those things. Do we have, I know this is something we discussed in the beginning, we didn't have like a program or anything for keeping this information on file for properties and property owners.
We didn't have an internet program or an electronic program, I think is what we talked about.
Right.
It's all
a
paper.
database, right? A database. So do we have that now? Is that what is happening now?
Nope, that has not been approved. It's not in the budget that has been. It was presented to the administration, whether it's going to get approved or voted on in the upcoming budget cycle. That's something for the administration and the council to discuss, and whether it's going to be even presented to the council. I don't know where that's going to be, but I did mention, I provided that information. So, so whether it's going to be approved or not, I cannot tell you that. Regarding the filing fees, the only thing is that I will tell you about this. The filing fees are for the anytime a resident or an owner. My interpretation of this, that when the owner takes over the property, they're to file a fee, a one-time fee. I cannot tell you if these particular owners have filed. Some of them have been owners for a very long time. There is no record of whether they filed or not. So we had discussed in the past whether we just decide as or not us, but even the council, whether they just say, let's start from the beginning and move forward from there, or whatever the case may be, because there is no record that I have that I see in my office that can tell me that whether somebody has paid or not. And right now, what we're doing is we've started with. I set up those forms and everything else. I am discussing with some landlords, and they are starting to send them in like that, but we still haven't had full compliance yet. But that, again, that goes down to, that's an operational function of this office, that You know, I told you
Although
about
one of
the
the things we could do as a board, I was going to suggest that one of the things we could do as a board, since there is no record of previous fees and filing, is we could set a date for the future and start announcing it to say that, you know, effective 1/1/2023, all multiple dwelling landlords must file, and you know, we can force a new date for compliance, if that's what the board wants to do.
I think that might be our only option. I mean, there's no record of anyone complying previously. We don't know who has and who hasn't. The only way to institute it is to kind of announce it, because a lot of people probably may not know about it, like you said, and give it a deadline.
I will tell you from an operational perspective, that is going to be a great undertaking. And I'm going to tell you something right now. I can't promise you that it's going to be completed by this office. I mean, it's a great undertaking, and with the other responsibility. And I'm not disagreeing that it shouldn't be done. I'm just saying, practically, I don't know, given the amount of properties we have and the amount of things that we have to do, you know, it's going to take some resources, some, you know, personnel resources to get this accomplished. And so that is something I'm going to have a discussion with the administration in order to accomplish it. So, and it's not saying that we won't do that, but as the councilwoman pointed out, you know, if we put an anticipated date to start it, that we can build toward it and do, you know, do projections and, you know, and set our goals to start this. Yeah, we can do that, but practically speaking, right now, it's going to be very difficult to get accomplished.
Peter, I mean, first of all, you really have done quite a bit already in terms of preparing forms that can be used, you know, that will assist in record keeping going forward. When I initially went through this ordinance, you know, my initial concern was, how does the board determine what the base rent is? Because as I recall, there's language in there that goes back to like 1993 in the most recent version of the ordinance. And we have no records of what the rent was back in 1993 or for that matter, last year. So how does the board determine what the base rent is in any application? Number one. Number two, the fees involved also were last modified, as far as I can see, back in 1993. If they were modified then, you know, economics have changed since then and so forth. So I'm not saying that they're no longer viable, but, you know, it's something that certainly ought to be talked about, because, you know, fees have gone up for everything else over the course of 25 years. Presumably they would for something like this too. And I think generally fees are used in a government setting to try to recapture the cost of enforcing the ordinance. So we ought to be able to figure out what the costs are here to have a hearing, for example, in terms of time, expense, you know, advertising, lawyer fees, and so forth, and figure out, you know, what a fair fee would be to charge a landlord or a tenant to make an application. And we don't want to treat anybody unfairly or make the system unavailable, you know, because of economics. But those are the initial things that came to my mind, as opposed to some of the other substantive changes that have been suggested here. And I think those are pretty basic. So.
Everybody, we're getting close to 10 minutes left in time.
I do want to throw something out there just for food for thought before we leave. You know, when you're discussing the ordinance, I have received recently from quite a few landlords. It's, you know, more than a handful, less than a dozen, inquiring about the actual rent increases of the 2% and 3%. And there is concerns with the, you know, the current economy and the way things are going right now, the costs, that they don't feel that it is correct. And that's just for discussion. I'm not giving you my opinion one way or the other. But I am receiving those calls, and I think it's responsible. I'm responsible to make sure that you hear that, because there are people who want to do capital improvements, and I'm talking large buildings. I'm not just talking the person owns the 3 and 4 family homes. I'm talking major projects and things of that nature. So that is something to consider, and that may be something that if we don't address that, or if it isn't addressed, should say the board, that you may see more applications for capital improvements and things of that nature. So I'm just letting you know that, because that's some of the reasons why some of these particular landlords have called in, because they're looking to do capital improvements. And we know that right now, most estimates are only lasting 30 days now, because most companies can't guarantee what the price of a building material is going to be in 30 days. So
right, and remember also that 2 to 3% number again was created many decades ago.
So I'm just throwing it out there for you guys to realize. I consider that, because given the current economic status of times that we're in.
Mr. Smeraldo, I think I brought that up at the last meeting, and I was saying that same thing for me. Just from a real estate professional perspective, the landlords that I have been dealing with and listening to are all complaining that the 2 and 3% increase is not enough, especially given the accelerated cost inflation of everything right now, given post-COVID.
Yeah, and so a lot of these landlords I'm talking to also own properties in multiple properties in multiple communities, and a lot of the other communities have raised their rates. That's what they're telling me. I can't. It's basically hearsay, I guess. But this is what they're conveying to me at this time. So I wanted to pass that along to you.
Right. So have these landlords applied for rent?
Nobody has yet, but they're inquiring. I will tell you this: they are inquiring.
Well, that's why I think it's important to have a mechanism for. Well, now that we're able to have the hearings, this is part of the reason why we're here.
Is there data available for other communities for us to gain an appreciation in other townships as to how much they increase in rents?
You can just go on most municipal websites and look under rent control. And if they have rent control, their ordinance will speak to what the percentages are.
But I also believe that is that a state figure? Like the state of New Jersey's rent control, there's like a New Jersey tenants, what is it? It's on our website as well. Hold on one second. I'm going to try and
tenant relations.
Tenant rights or something. I think
tenants rights. That was published through an advocacy group that we put up on the website. And there's also the Truth in Renting, which was put out by the DCA.
Okay, one second. I just feel like the figure I thought was like a standard figure when I saw.
It's not a standard figure. Each town has its own. I mean, there are some standard figures: 2%, 3%, 4%, 5%. But there is no standard across the board. Each municipality varies, but 2 and 3% is very low.
Right. State law gives municipalities the right, the ability to establish rent control ordinances if they want to. They don't have to. Not far from all of New Jersey municipalities have such ordinances, and they're all somewhat different. So we're on our own.
And Melinda, you may have been referring. There's a section in I think it's in both documents where they talk about unreasonable rent, and they give examples of what unreasonable rent may be. And I think that may be what you're referring to. I don't think they actually gave the actual amount, but they were just discussing what the tenant's rights are and what may be deemed an unreasonable rate increase, and what their options are to object to it. That's really what it came down to. So
you don't have to table anything, by the way. This is a workshop session, and I think, and we're just discussing ordinance it's listed as ordinance discussion. So it's nothing that has to be tabled. And I think this conversation and thinking about this is going to be an ongoing process based on all the discussion we've had tonight. And again, I don't need to participate in all these things. I just figured I would kind of get the lay of the land here, and knowing that at the end of the day, I'm going to have some responsibility if there's a change in the ordinance to work on it. So, and I'm happy to help any way I can, answer questions. I really can't participate in hearings because the council may have an appeal of one of these hearings, and I can't represent you guys with respect to that, so.
Understood.
So I will reach out to the chair and discuss when we may want to have another workshop. And I would assume it will be after our next red leveling board meeting, which is a week from tonight.
Did we get an updated application from?
I sent it out yesterday.
Oh, okay, great.
As discussed at the last meeting, I told the applicant to send it in at least 7 days prior in order to be considered. He sent it in a timely manner, and I sent out the packets again, the entire packet with an updated second packet. And again, when we're discussing the size of the server, to ensure that it went out, I sent 2 separate emails. So the second email should have the updated packet that he sent in.
Okay, great. Yeah, I see it in my inbox now. Thanks.
All right, so you do have it for your availability. If anybody does need for me to download it, please let me know. I will tell you this, officially, we will be opening back up next week, the town hall, so you can come visit me if you want. I'm upstairs in the corner all by myself. Bring breadcrumbs to find your way back out. I will put all that. I'll get that information out to you if you need anything else. I won't send anything more because that's the application. I believe Mr. Vistaros, he was the one who sent that application in. So, and that's all we have for now. I will send out on Tuesday the final agenda. We won't put anybody else on for a hearing because, based on the conversation, we want to have enough time. So nobody else will be on the hearing next week. So that will be the only item as far as applications. So I will send out the final agenda on Tuesday. And so we're all scheduled to go. So.
Mr. Moraldo.
Yeah. Yes.
Is it a desire of the board to establish a standard so that if materials aren't received 7 days prior to a hearing date, that it won't be put on the schedule or the agenda?
Correct.
So that the board members will have an opportunity? But did we establish that as a 7-day standard, or is that just what we're going to put into practice?
We put it as a practice for now. We can put it into a standard. That would be up to the board to decide that if they want to discuss that. Maybe at the next meeting, we can put rules and regulations that guide the board in play. And maybe we can have that subcommittee provide some of them so we can put it on the agenda for next time. But that was going to be the practice that we established based on last month's meeting. So
I just think we should probably firm up that practice so that if there's something that comes in 6 days ahead, prior to, that at least we have some practice.
I think if it comes down to that, as the rent leveling board office, I could even just establish policies and procedures that doesn't have to go through the board, and I'll just make that the policy and procedure.
Okay.
Just handle that on my own, and that's that. And the chairperson has nothing to say about it. No. So we could do that. I could establish some office protocols and policies and procedures, and I could even, once I create them, I could post them onto the website so people know, so they know exactly what they have to do.
Thank you.
I can even add it to the checklist. We have the checklist. I could add it even to the checklist where it says, this is what if you do not send it in 7 days prior to the scheduled meeting, you will not be approved or put onto the agenda. So.
Okay.
Right.
Okay. May I ask, have any of the subcommittees had an opportunity to meet amongst themselves?
Yep, Kabir and I have met 3 times now on the budget side. We submitted that stuff to Pete maybe 4 weeks ago. I don't know.
Yeah, I believe we sent all that stuff out. Yeah. Anything the subcommittee send to me, I send out to you guys. It's in the just search for. I send it out as a BCC, so this way it doesn't violate the Open Public Meetings Act. So just look into your in your inbox and see if it's there. I always send it out to everybody. If you're having difficulties getting something, let me know. I will resend it to you. But I send everything out that I get, because if I don't send it out right away, I'll forget about it. So as soon as I receive it, it goes out. So if you don't see anything, let me know. I will resend it to you. But just Google, do a search in your inbox for rent leveling board or my name, with my email, and it should pop up. Okay.
No, I was just wondering if any of the subcommittees had anything to report upon.
It's 6 o'clock and we cannot go any further than that. So I stick to the rules here. So we're going to be.
Yes, they won't be.
We had a
reporting
10,
upon.
so that will be for the next meeting. So it is 6 o'clock. And if there are any
Okay.
reports, I will ask them to send it to me. What I will do now, because it is 6 o'clock, we're going over our time. I just want to say, any member of the public, again, who wants to, has a question for tonight, I don't believe anybody was on here tonight. If they do want to talk, ask me questions, please contact me at 973-325-4107 or peacemeraldo@westorange.org, and I will answer in a timely manner. And for the members of tonight's rent leveling board, I want to thank you for coming in. And to the chair, I will discuss with you offline as to setting up another date for another workshop, because it appears that we're going to probably need one. If anybody has any questions otherwise regarding next week's meeting, please give me a call. I want to say good night to everybody and thank you for participating.
Thanks, Pete. Thanks, everyone.
All right.
Thank
All right.
you.
Do we need a motion?
Nope.
Okay, have a good night.
I'm in favor of it though. See you later.
Bye.
Bye.